Now, having watched the oral argument at the United States Supreme Court on birthright citizenship, I think maybe the far right took the case in order to embarrass and chastise Donald Trump. That's how bad things went today. In breaking news, a highly skeptical far right of the court went after basically tooth and nail the Solicitor General for the United States' argument to try to rip the beating heart of birthright citizenship out of the 14th Amendment. Not only weren't the liberal moderates on the Supreme Court buying whatever he was selling, the conservatives weren't buying it either. And Donald Trump had two major historical occurrences today. First sitting president to ever attend an oral argument at the United States Supreme Court, and the first sitting president to ever leave before the oral argument was over, when he knew his goose was cooked just 45 minutes into the oral argument, as John Roberts, Amy Coney Barrett, Kavanaugh, and Gorsuch took turns like making John Sauer into some sort of constitutional piñata about his illogical, nonsensical, not rooted in history or language arguments. I'm Michael Popok. You're on MeidasTouch and Legal AF. This is where you come for this kind of news. We had the live feed. It's still up on Legal AF YouTube channel. You can listen to it, the 2 hours or more for yourself, but I'm going to curate for you what I think you needed to know. Let's frame the issues. The 14th Amendment in the Citizenship Clause says that a person who is born or naturalized in the United States and subject to the laws thereof is a citizen of the United States in any state in which he is born or naturalized, period. Now, Donald Trump wants to convert that into and invert that into, no, that was passed to cover newly freed slaves. That's slave babies. Donald Trump actually said that in a social media post. It doesn't say slave babies. It says all persons, any person. And when the Constitution and its framers or the creators of amendment use broad language like person, they mean all persons regardless of immigration status. Just like in the Fourth Amendment, all persons are safe and secure in their homes and in their papers from unreasonable search and seizure. It doesn't say only those that are here on proper documented status. So Sauer doesn't get to use, as the Solicitor General and Donald Trump's former criminal defense lawyer, he doesn't get to use historical antecedents. And, well, this is what the back in 1868, what they would have believed, because there's no ambiguity in the language of the 14th Amendment. So you never get to legislative history. Even if you get there, John Sauer, as he reliably does during his oral arguments, often makes illogical statements, jurisprudential leaps that make no sense. And then when he's challenged, he doesn't back off from it, where he loses all credibility. There were four major pieces to today's argument, four major pieces of the puzzle. One, the language of the 14th Amendment that I just referred to. Then the fact that Congress in 1940, during World War I, 1952, during the Korean War, codified the language of the 14th Amendment into statutes, into congressional law that were identical to the language of the 1868 Amendment to the Constitution, which came out during our Reconstruction period. So you have the statute in 1940. You have it reaffirmed in 1952. You have the original 1868 amendment. And then you've got a case, Wong Kim Ark, from 1898, in which the Supreme Court ruled that somebody whose parents were not citizens, that was born in the United States, a Chinese baby, was an American citizen. And when you put all that, I mean, that's really what this distills down to. And the right-wingers on the Supreme Court took turns using John Sauer as a punching bag on these various points. Kavanaugh took the Supreme Court precedent and the congressional statutes from 1940 and 1952 to argue, well, how? You said it was newly freed slaves. Is that what Congress was considering in 1940? Not newly freed slaves? What about 1952? And then Amy Coney Barrett went into, how do you square the language of the statute with the language of the Constitution? And John Roberts probably had the mic drop of the day when he said out loud, after John Roberts said, it's a new world with 8 million people in it. And John Roberts effectively said, but it's the same old Constitution. Okay, let's get to it because I know you want to hear these clips. The thing started at about 5 after 10 in the morning Eastern time. Donald Trump took his seat front row behind, he had the red velvet drapes there and curtains at the United States Supreme Court. First row, red tie, sitting there, hands folded. He's been in court before as an indicted and convicted felon. So he knew his way around the room, if you know what I mean. And then it starts. And let's just, in no particular order, when John Roberts says there's 8 billion reasons why we need to change the language of the 14th Amendment through executive order, listen to this exchange he has with the Chief Justice John Roberts. Play it.
Their interpretation has made a mess of the provision.
Well, it certainly wasn't a problem in the 19th century.
No, but of course, we're in a new world now, as Justice Alito pointed out, where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
Well, it's a new world. It's the same Constitution.
It is, and as Justice Scalia said, I think in the case that Justice Alito was referring to, you've got a constitutional provision that addresses certain evils, and it should be extended to reasonably comparable evils. He said that about statutory interpretation. I think the same principle applies here, and I think we quote that in our...
And it got no better when Amy Coney Barrett started asking questions. Amy Coney Barrett and John Roberts will likely form the bloc. I think John Roberts writes this decision against the Trump administration. I think he's definitely joined by Ketanji Brown Jackson, Sotomayor, and Kagan. So there's at least 5 votes. I think Gorsuch and Kavanaugh come over too. I think it's 7-2, could be 8-1 against Donald Trump. It will get the decision at the end of June. Here's Amy Coney Barrett going after the nonsensical arguments of John Sauer. Play the first Amy Coney Barrett clip. Play it.
Concept that creates allegiance. That's
General,
so
you said in your reply brief that the children of slaves who were brought here unlawfully, in defiance of laws forbidding the slave trade, would in fact be citizens. And
yes.
We can imagine that their parents were not only brought here in violation of United States law, but were here against their will, and so maybe felt allegiance to the countries where they were from. And you say that the purpose of the 14th Amendment was to put all slaves on equal footing, newly freed slaves on equal footing, and so they would be citizens. But that's not textual. So how do you get there? You say it in just a few sentences, so can you elaborate?
Sure. If you look at the 19th century sources, what you see is that even though their entry may have been unlawful, 19th century antebellum law never treated their presence as unlawful. In fact, quite the opposite.
Then it was Gorsuch's turn. Now, Gorsuch, very interesting, many times sides with the far, far right of the court, Alito and Thomas. He's done it in a maddening amount of times. But sometimes, like in the tariff decision, he breaks away and follows Amy Coney Barrett and John Roberts. It's increasingly becoming the Amy Coney Barrett court because, as we will see with the statistics at the end of this term, she will have voted more in the majority than any other person, making it really her court. She becomes the swing vote, if there is such a thing as a swing vote when it's a 6-3 MAGA majority. But Gorsuch sometimes follows along. Here's Gorsuch going after and beating John Sauer with both ends of the stick. Play it.
I'm just working within your argument for a moment. Today, you can point to laws against immigration that are much more restrictive than they were in 1860. We really didn't have laws like that we do today until maybe 1880. So if somebody showed up here in 1868 and established domicile, that was perfectly fine without respect to anything, any immigration laws. There they were. And so why wouldn't we, even if we were to apply your own test, come to the conclusion that the fact that someone might be illegal is immaterial?
I would first cite Wong Kim Ark on that point, because Wong Kim Ark says you're...
Well, I'm not sure how much you want to rely on Wong Kim Ark.
But there is a statement in there that says, so long as they are permitted to be here. So Wong Kim Ark, keep in mind that by the time they decide Wong Kim Ark in 1898...
but that's 1898. Now I'm looking at 1868, you're telling me is when I should look, and the test for domicile. And the stuff you have about unlawfully present, it's like Roman law sources you're going to.
First and second restatements as well. And
if John Sauer thought that Kavanaugh might be, he's got to count votes too, right? He's got to come up with 5 votes. That's how many it takes to support the president on this position. Got to count to 5. So that means he needs Alito and Thomas, and then he needs some combination to count to 5 of Kavanaugh, Gorsuch, Roberts, and Amy Coney Barrett. So he's got to get 3 out of the 4 there. And then it would be a 5-4 in favor of Donald Trump. I don't know where he gets the votes from. And if Sauer thought, John, that Kavanaugh was going to help him, another Trump appointee, Kavanaugh starts talking about, well, you've got a 1940 congressional statute that uses the same language. It certainly is not talking about babies of slaves. 1952, you've got the 1898 case from 30 years after the amendment. How do you square that with your argument? Play Kavanaugh.
This in your opening, that if we agree with you on how to read Wong Kim Ark, then you win. So that could be if we did agree with you on Wong Kim Ark, that could be just a short opinion, right? That says the better reading is respondents' reading. Government doesn't ask us to overrule, affirmed.
Yes.
That's that. Then last question though, why would we?
And then we got Amy Coney Barrett all over again. Amy Coney Barrett back in the fray. So if he thought maybe he had changed her hearts and minds, she disabused him of that with this exchange. Play Amy Coney Barrett.
Okay, let's talk about its applications. So, there are some, I can imagine it being messy on some applications. So what would you do with what the common law called foundlings? The thing about this is then you have to adjudicate. If you're looking at parents, and if you're looking at parents' domicile, then you have to adjudicate both residence and intent to stay. What if you don't know who the parents are?
I think there are marginal cases. That one, I think, has the benefit of being addressed in 1401F, where it talks about
Yeah. But what about the Constitution?
Under the Constitution, domicile is a constitutional standard in all kinds of other situations.
Well, and it's hard.
Diversity jurisdiction, personal jurisdiction, sorry.
Well, yeah, and personal jurisdiction, 1332, diversity jurisdiction. And the thing is, it has to be litigated because it turns on intent. And both the virtue of both jus soli and jus sanguinis, whichever one you pick, it's a bright line rule. How would it work? How would you adjudicate these cases? You're not going to know at the time of birth for some people whether they have the intent to stay or not, including U.S. citizens, by the way. What if you have someone who is living in Norway with their husband and family, but is still a U.S. citizen, comes home and has her child here and goes back? How do we know whether the child is a U.S. citizen because the parent didn't have an intent to stay?
I'd say make 2 points, one practical, one legal. The practical point is under the terms of this executive order, you don't have to, because the executive order turns on objectively verifiable things, which is immigration status. Are you lawfully present but temporarily present, or do you have an illegal status? So those kind of taking evidence, so to speak, under subjective intent wouldn't be done. And as to the constitutional point, obviously domicile is baked into a lot of constitutional and legal concepts, and there may be situations where facts are determined. But if you look at the guidance that all the agencies did after this court and Costa said the agency could go forward and issue guidance, the guidance provides, I think, very, very clear, objective, verifiable approaches to doing this. And so as a practical matter, I don't think it's presented by this executive order.
Thank you, General.
Justice Jackson?
And of course, we have the intellectual center, the intellectual leader of, I love Sotomayor, but Ketanji Brown Jackson is quickly becoming, in my view, the future of the United States Supreme Court, including, I hope, a Chief Justice of the United States Supreme Court. She's the embodiment of what we want on the Supreme Court. And she just got right to the point with her questioning. Here's Ketanji Brown Jackson. Play that.
You will still get
not transparent. I'm just talking about the particulars, because now you say your rule turns on whether the person intended to stay in the United States. And I think Justice Barrett brought this up. So are we bringing pregnant women in for depositions? What are we doing to figure this out?
No, as I pointed out earlier, the executive order turns on lawfulness of status. So if you give birth to a baby in the hospital right now, it gets the birth certificate in the system. There's a computer system.
So there's no opportunity. There's apparently no opportunity then for the person to prove or to say that they actually intended to stay in the United States?
Absolutely not. The opposite is true. Their opportunity to dispute if they think they were wrongly denied, which would only happen in a tiny minority of cases, is directly addressed in that guidance.
After the fact.
Yes.
After their baby has been denied citizenship, then we can go through the process.
Yes. And the way that, I'm summarizing because I'm not an expert in computers, but there's a computer program that currently automatically generates a Social Security number. SSA says, look, a Social Security number, non-citizens can have them if they have work authorization, so it doesn't prove citizenship. We'll give you a Social Security number, provided that the system automatically checks the immigration status of the parents, which there are robust databases for, and then it appears no different to the vast majority of birthing parents.
Thank you.
Now, I could have led off with Ketanji Brown Jackson and Sotomayor and all that, but just the fact that my clips curated for you were Roberts, Amy Coney Barrett, Gorsuch, and Kavanaugh, I question where Donald Trump gets more than 2 votes at all. And he knew it. And Donald Trump walked out after about 50 minutes in, he saw Roberts and Amy Coney Barrett going after John Sauer. Now remember, he had this to say about Roberts and Amy Coney Barrett the last time when they voted against him on the tariff decision 6-3. Play Donald Trump.
The Supreme Court, that's right, of the United States cost our country, all they needed was a sentence, our country, hundreds of billions of dollars, and they couldn't care less. They couldn't care less. And not that it matters, doesn't matter at all. But 2 of the people that voted for that, I appointed. And they sicken me. They sicken me because they're bad for our country.
And this is not the first time Donald Trump has a giant tell that what he knows he's losing. Walking out on a proceeding is part of his MO. He did it today to set his new history in the history books, but he also did it when Robbie Kaplan, the lawyer for E. Jean Carroll, was in the middle of her closing argument in front of that jury, in which E. Jean Carroll ultimately recovered over almost $100 million for proving to a jury that she was sexually abused in a dressing room at a department store in New York, diagonal from Trump Tower. He didn't like Robbie Kaplan and showing her disrespect and proving all the misogynistic points and proving all of the evidence. He got up, turned on his heels in front of a jury and walked out. Now, I interviewed E. Jean Carroll along with the Court of History on Legal AF, and she said that in her mind was the turning point, that so turned off the jury and proved their entire case for them. That and the fact that he had confused in a photo E. Jean Carroll for his first wife, that moment where Donald Trump impulsively can't control himself and marched out in front of the trier of fact, or in this case, in front of a Supreme Court. He's just a toddler in a high chair. So get ready. Without any reservations, I think this is going to be 7-2. I don't think it's 8-1. 6-3 at the worst, all against Donald Trump and preserving the language of the 14th Amendment and leaving the beating heart of birthright citizenship inside the Constitution where it belongs. This was an existential fight that we're watching for the soul of America at the United States Supreme Court today. And fortunately, I can report, I think we survived it. Why I say it's existential is that, are we going to have different categories of Americans? Is my wife a naturalized American, worse or better than me as a native-born American? Are we going to have levels of American? I mean, you have the MAGA talking about heritage Americans. I thought heritage Americans were the Aboriginal people. I thought it was the Native Americans that were here first anyway. No, it's how many generations you can count back. No, forget all of that. And they will declare, I think, at the end of June, when they go on their summer holiday and drop this bomb of a decision on Donald Trump after the tariffs, they will declare once and for all that the 14th Amendment says what it says. And whether you're here on a tourist visa, you're here on an asylum application, you're here with no immigration status at all, and your baby that's born here is an American. And that's a good thing. One last note. We're winning some big matters. Thinking, freedom-loving people are winning some matters now at the Supreme Court. Doesn't change the calculus that we've lost 90% of the shadow docket issues. And it doesn't change the fact that they've given Donald Trump immunity or let him lop off the heads of federal agency heads without regard to what happens, or cut off funding, or to hurt people. But we are winning some major cases now at the United States Supreme Court as they turn to the merits. We'll probably lose a couple of voting rights cases, a couple of maps cases, but I think we'll also have some wins, like the independence of the Federal Reserve. And there's going to be a lot of decisions now between April and June that are going to be dropped. Another couple of oral arguments coming up. We'll follow it on MeidasTouch and on Legal AF. Come over to Legal AF, hit the YouTube subscription button to help us continue to grow our pro-democracy channel. Till my next report, I'm Michael. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.